Hi, I'm Swift Law North Chief Legal Officer Jordan Isringhouse. I'm here today with Chief Executive Officer Swift Law North, Aaron Swift. Welcome, Aaron.
Thanks, Jordan.
So title of this video, Pay Up or Else. This is in our FDCPA series. I may have already said a violation. So Aaron, just to jump right in, I want to talk about some common violations, and I want you to give me a little bit of commentary, your perspective, and kind of how you view some of these violations. So
Okay.
In terms of, what about harassing language for
Okay.
debt collection? Tell me a little bit about that.
Yeah, it's a good starting point. So just generally speaking, debt collectors can't harass you or your consumers or clients. It sounds so simple, but what does that mean? You know, what is harassing to one person to the next? And one thing I would say is retie back into the standards topic we had a video series on, because you're still going to be looking at it through the least sophisticated consumer. So what's harassing to a least sophisticated consumer may not be harassing to someone older or more wise or more intelligent or has, more life experience, but that can still apply. So it's kind of a low bar. So, debt collectors should not be swearing, they can't threaten, they can't use overly abusive language, and it's going to be fact dependent. But that's just a general proposition, and it makes sense. What this law was meant to do is to protect consumers against debt collectors, and the first thing is don't harass consumers.
Okay. What about when the debt collectors contact these consumers?
Yeah, good question too. So there are rules and prohibitions on contacting consumers in a number of ways. One is time. So you can't call someone after 9 p.m. or before 8 a.m. to collect the debt. And I referenced that hypothetical in an earlier video because that can trip some folks up, especially if you move from one time zone to the other. But there are protections. You're supposed to be sleeping. You're supposed to be taking care of your family, maybe getting up in the morning, getting ready for school or work, or getting your family ready. And that's not a good time to receive a debt collection call.
Okay. Are those, any new guidance out there about, because I know we're in kind of this new world of, people have cell phones everywhere. They carry them with them, and maybe that's not so new, but different ways you can get in touch with someone on a cell phone. It's not just a phone call anymore.
Right. So I think in an earlier video I talked about this law was originally passed in 1977, before the internet existed, certainly before cell phones or smartphones that exist, so ubiquitously in everyone's pocket just about. So there were new regulations updated under what's called Regulation F that amended and strengthened the FDCPA in a number of ways. And some of those protections are now you cannot call a consumer more than 7 times in a week or in a 7-day span. So we basically now said anything above that is now harassment as coded by statute. You also, if you connect to a consumer, you have to wait 7 days to call them again. And that's to stop the repeated, incessant getting calls every day, multiple calls a day. So if you make a connection, you have to wait 7 days to call again. They also place prohibitions on new ways of collection. And we mentioned smartphones, but also social media, which exist on our smartphones most of the time. Debt collectors are now even using those methods to send direct messages through Facebook or Instagram or X/Twitter. And this is a new world. So with changing times, we have to change these protections. And so the FDCPA carries a lot of new protections that didn't exist before. Another one is what's called a drop voicemail. What that is what it sounds like. This is a company that has negotiated with the carriers to say, I'm not even going to have to ring this person's phone. I get to drop a voicemail just right into their voicemail bin, which on one hand was supposed to, well, now I'm not harassing as much, or I am keeping people from leaving voicemails, and I don't have to call them. It's not disruptive. But we said, no, you have to get permission to do that. That's a practice that the practice of calling the consumer gives them a chance to know who you are. You can interact. They can try to negotiate with you. Just leaving a voicemail with no call is now not allowed.
Okay, so that's some of the new stuff and some of the new methods and means of debt collection. What about the old school, just debt collection letter? I mean, anything? I mean, are those governed in the same way? Take me through that.
Yeah, good question. That's certainly a classic way that debt collectors communicate or try to communicate with consumers. And there are rules to govern those as well. So One example is the first time you have a contact with a consumer, whether that's by phone, email, text message, or letter, you have to give them certain disclosures. And when it's a letter, they're usually in that disclosure letter. And the statute defines exactly what you have to say. And that's information to help the consumer know who you are as a debt collector. Because remember, these are third parties. Incredibly important to always remember that in all of these videos. And since the consumer may not know who this new company is, you have to tell them, well, I've been hired by X. That's the original creditor. That's the debt I'm trying to collect from you. This is the amount of that debt. This is any interest or fees that are going to be charged, if allowable, on that debt. And there are other things, but it's a model disclosure notice. It's meant to give the consumer more information and better information to make an informed decision, so the consumer knows who sent them the letter.
Okay. What about so that's kind of some of the identifying information and everything. How about the inside, the content of it? I mean, like, can they say, hey, we're going to come steal your dog or something? I mean, is there any limits on what they can say?
Absolutely. So the same kind of guiding principle of no harassment would apply to a letter, call, any type of communication. But you also can't make false threats. This is a classic example. A debt collector may send a letter that say, hey, we haven't credit reported you negatively yet, but if you don't pay us, we're going to. Well, if they don't follow through with that, that was a false threat. And you can't basically lie to a consumer as leverage to get them to pay you. And that happens a lot in letters.
Yeah, and in that vein, it's something that I see happen in letters where consumers come in is it looks so official. It looks like it almost has a seal on it. Sometimes it even references like an attorney or something like that, which I guess sometimes can be true, but is there any times where it can't?
Yeah, and that's a really good point. Actually, I'm going to break that down into two sections. So one is you certainly cannot impersonate a law enforcement officer, an attorney if you're not one, a judge, a government agency. And we see that sometimes. Really shady debt collectors will send like fake summonses. They're saying, we're going to sue you. They haven't yet, but they make it look like they did by sending what looks like court papers. And certainly the least sophisticated consumer is not going to understand that, let alone even sophisticated consumers, because they look official. Yeah, that's certainly something you cannot do. You can't impersonate a judicial process or a lawyer. And the second part of the answer is there are lawyers in this industry. You know, there are debt collection lawyers, and they're very prevalent. They have to be careful when they send letters, because getting a letter from an attorney is probably scarier. You know, it has more impact than getting a letter from a standard debt collector. And so that gives them a lot of power, but they have to be careful. And one thing, for example, if it's sent by a law firm, they have to tell you, has this been reviewed by a lawyer yet? And if it hasn't, they have to tell you that. And that's supposed to soften the blow. Not sure if it does, but that's an example.
Okay. So this is a lot of like really specific examples. Is there any way, like, so is there a way that someone might still be the subject of illegal debt collection, but it's not like on this list that you're talking about?
Yeah, sure. There's a whole host, and I would encourage everyone to read the statute. You know, 1692C starts the prohibited practices, and then section D and E as well. And I'm going to list some other common things. You can't collect an amount from someone they don't owe. That makes sense, right? That's a prohibition. So that could be in the form of you don't owe it at all because it was a fraud account or identity theft, or you owe $200, but they're saying you owe $600, or charging an illegal fee, for example. You can't do anything that changes the character, status, amount of the debt. That all has to be true as you communicate it to the consumer.
Okay. What about, you kind of referenced this earlier in talking to, someone calling someone's office,
Yes.
talking to another person. A lot of times that's just really vague communication too.
Right.
Could that still be the subject of a bad debt collection?
Absolutely. So one of the hallmark protections of the law is harassment, but also privacy. So this is a company that you didn't contract with, the consumer, and now they have a lot of personal and private information about you, whom you may have contracted with. They might get information about your credit, your social security number, because a lot of times they get the full file from the creditor, the person that they're representing. And that has to be protected. But what a lot of debt collectors do, unfortunately, is they'll contact other third parties to try to get to you. And that is not allowed in a lot of ways. For example, you mentioned my earlier example of someone calling a workplace. That in and of itself is dangerous because you can get someone fired, if you incessantly call someone at work, but you also may get pre-screened by a receptionist or an assistant. And debt collectors often will leave, this person owes money, please have them call us back. Well, now you have disclosed personal private information to a third party. You can't do that. So that can be references on a credit application you can't call. You can't call neighbors. It doesn't happen as much anymore, but the really bad debt collectors, they'll call your grandmother. They'll say, hey, Johnny is $10,000 behind on his debt. I'm going to sue him. They found the grandmother because they did a skip trace or they did some background checking on you. And they say, but if you pay us $6,000 now, Johnny doesn't go to jail or Johnny doesn't X, Y, and Z. And that's just particularly kind of shameful. So you can't contact third parties.
What if someone's already hired a lawyer to represent them about a particular debt? Like say they, hired someone to help them file bankruptcy, or they hired someone because, oh my gosh, like maybe they actually reached out to you and said, oh, I'm having a really hard time with insert debt collector here. I mean, can they still get contacted?
It's a good question. So we're now going to kind of shift to some violations that prohibit contact to the consumer in certain ways. And that's a really good one. So if a consumer goes through the trouble or has the courage, is very proactive and hires an attorney, whether it's to, like you said, file a bankruptcy in the future, to defend a case, or just to help, I'm being harassed and I need help. If that attorney puts the debt collector on notice of the representation, that stops, basically puts a wall between them, and you can no longer contact the consumer directly. That happens all the time though. So say, for example, consumer comes in through our litigation program, we send out letters on behalf of the consumer, that's a stop, and they can't contact. They have to work through us. We're basically now that consumer's agent, and it's a really important protection.
Okay. Any other way to get a debt collector to just stop calling you, stop sending you letters, just stop? Is there any way to do that?
Absolutely, and you kind of just said one way. You literally can just say stop. Because this is a protection statute, once someone says stop or I don't want to hear from you anymore, if you keep doing that, that's harassment. And debt collectors have the right to collect debt legally, and they have other avenues. They don't have the right to be able to call you all the time. So if you ask them to stop, certainly in particular ways, they have to stop. You can also send a written cease and desist. And that can be in the form of a lot of things. And there's some even new case law that suggests you don't have to use magic language. You can say, I refuse to pay this debt, or I don't think I owe this debt, leave me alone. And again, that's because it's the least sophisticated consumer. So there's no magic language. You can say, stop calling me. If they keep calling, that's a violation. You can write them a letter and say, I don't want to be contacted anymore. See you in court, or whatever. And then the debt collector has a choice. It can send the account back to its, the person that hired it, the creditor probably. It can sue, but what it cannot do is violate your rights by continuing to contact you after you've told them to stop or asked them to stop in writing.
Okay. Let's say that a consumer has a debt and they start getting debt collected, and for whatever reason, it's just not the debt information about the debt just isn't correct. And a consumer goes about, like, let's say the debt collector actually gives these appropriate disclosures, and the consumer takes them up on it and says, hey, I do dispute this debt. Here's why I dispute the debt, etc. Is there any, legal impact to that? Is that just go out into space and it doesn't have any sort of repercussions?
So it's interesting you said that. It tickled my brain. One of the model notice requirements, we talked about the disclosure rights earlier, is you have to tell the consumer that they have the right to dispute the validity of the debt or any portion thereof. And that could be a $10,000 debt, but I can dispute a $25 late fee if it didn't exist. And if a consumer does take them on that right, up on that right and disputes, it triggers a couple of very important things. And one of them is, you must now tell anyone that you've communicated that debt to that the debt is disputed. And in practice, what that means is credit reporting. So if you go through our litigation program, or you've worked with one of our professional partners, or you're being educated through this lecture series, you realize you have the right to dispute the debt, and you communicate that to the debt collector. If they're credit reporting, and usually they are, but not all the time, if they are, they have to mark that debt as disputed. And if they don't, it's an FDCPA violation.
Okay. Well, thanks, Aaron. I think you've taken us through quite a laundry list, as you described it, of common FDCPA violations. So if any of our affiliates or any consumers have any questions, continue to watch this FDCPA series, of course, and you can contact Swift Law North and any of in our affiliate chats, etc. So thanks for joining us.
Thank you.
And